case briefs, and so much more. LSData's got what you're looking for.
In 2008, Alabama Supreme Court heard a case involving the Industrial Development Board of the City of Montgomery, IDB, and Hyundai Motor Manufacturing Alabama. McLemore v. Hyundai Motor Manufacturing Alabama, LLC, centered around the interpretation of contracts and how their language should be understood. The plaintiffs, a group of landowners including George E. Russell, Thomas E. Russell, Murtis Russell, Price McLemore, sued the IDB and Hyundai for breach of contract. The issue arose when the IDB acquired option agreements from the plaintiffs, which set a purchase price determined by either 2 appraisals or the same price paid to any other landowner in the project, with a minimum of $4,500 per acre. The IDB went on to acquire option agreements for other nearby properties, but not Joy Shelton's, which Hyundai asked CSX Transportation to purchase instead. The court found no evidence of joint venture between the IDB and Hyundai, but the language in the amended option agreement was deemed ambiguous, and the most favored nation clause was not considered waived. This led the court to reverse the summary judgment for the IDB and affirmed it for Hyundai, ultimately remanding the case for further proceedings. The issue of the trial court's discretion regarding the IDB's protective order was not addressed.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.